So I believe that we can slowly start. I will give the floor to the moderator, to Andrei Kosilo, who will be moderating this session. And the webinar is organized by the project Sunflowers in cooperation with EU Pravo Justice Ukraine. I also see that our colleagues, our interpretation team, they put on chat what to do to follow the interpretation. If you could just raise hand that everything works okay, we would be grateful. If you could tag in the chat that everything works and you can hear us loud and clear. Okay, so Andrei, I'm giving the floor to you as the moderator of our meeting today.
Thank you, Anna. Good evening. Welcome everyone to our webinar entitled War Crimes Prosecution, a lesson from the former Yugoslavia for Ukraine. My name is Andrei Kosilo. I am adjunct professor at the Department of Criminology and Criminal Policy, University of Warsaw. I am also a board member of the Sunflowers Foundation. The webinar is a joint event of the Project Sunflowers and the EU Pravo Justice project. The Sunflowers project was created after Russia's full-scale invasion against Ukraine in 2022. The project carries out two important tasks. The first one is to spread knowledge about the international criminal law by organizing conferences, webinars, and training. The second one is the creation and use of an application enabling the automation of the processes of collecting information on war crimes in Ukraine, which can be used as evidence by international justice institutions. We managed to do it. The application was created last year. The topic of today's webinar will be presented by Dr. Iva Vukusic, who is a historian and a genocide scholar, assistant professor in international history at Utrecht University, and visiting research fellow at the Department of War Studies, King's College London. The second speaker is Dr. Anna Adamska-Galant, former international judge in Kosovo, head of the judiciary component of EU project Pravo Justice in Ukraine. The webinar focuses on the challenges and opportunities of prosecuting war crimes and on the many difficulties ahead of Ukraine in an effort to provide some justice for survivors. Dr. Vukusic spent years working on accountability in the former Yugoslavia and The Hague, and will use that experience to provide some insights into ways forward for Ukraine. The webinar is, Anna told the webinar is conducted in English and simultaneous translate into Ukrainian is available. You can turn on the translate for Ukrainian language in your Zoom application. During the webinar, you can ask questions in the chat, questions and answers. Please enter them there. Dear Eva, the floor is yours.
Thank you so much. It's really a pleasure to be here, and thank you for the invitation. It is really an honor to be participating and discussing this important subject. I will do my absolute best to speak slower for the benefit of the interpreters, but if I'm too fast, which I think is my natural tendency, please interrupt me and let me know. So, as it was already announced, my perspective is one of a historian and a genocide scholar, and also a practitioner who worked in Bosnia and Herzegovina at the Special War Crimes Department of the Office of the Prosecutor. I worked as a researcher and analyst, working with prosecutors and investigators in building cases that concerned different alleged crimes during the war in Bosnia and Herzegovina, which was, of course, between 1992 and 1995. So I was in Bosnia about 15 years ago for a couple of years. But one could also say, I suppose, that I am a client, a user of international justice, because I am originally from Croatia. And I have also been following trials and accountability initiatives for something like 20 years now. And this includes efforts that concerned crimes in Syria in the past decade or more now, but also more recently events in Israel and Palestine and different legal proceedings that are going on here in The Hague, where I live. So the structure for this evening is the following. So I will start with a few observations and thoughts on international and then also national, so domestic efforts to achieve accountability in the former Yugoslavia. Then I want to discuss some challenges and some accomplishments. So what is it that war crimes prosecution can deliver, can give us? Then I want to discuss some key observations as they relate to Ukraine, including the International Criminal Court, so the ICC. And I will end with some lessons learned and recommendations. So lessons from the former Yugoslavia to Ukraine. What are some practical things that we can think about and keep in mind as we work towards providing some justice for crimes in Ukraine? So let me start with the ICTY and the local prosecutions. So the acronym ICTY refers to the International Criminal Tribunal for the former Yugoslavia. And this is the International War Crimes Tribunal, the first contemporary one that was opened in the aftermath of the Cold War. It was established by the United Nations Security Council in 1993. And it was made in such a way that it basically made the states of the former Yugoslavia, they were obliged to cooperate because this was a United Nations Security Council established tribunal. And there was a lot of pressure from various states and different actors on the former Yugoslavia to cooperate. And we can discuss this more in the Q&A later, but the enforcement was definitely stronger than the ICC has, that is available, so to say, to the ICC now. So the jurisdiction of the ICTY was over war crimes, crimes against humanity, and genocide. And it concerned events covering different conflicts. So from Croatia, from 1991, through Bosnia and Herzegovina to Kosovo, which was, of course, the war that peaked, I suppose, in 1998 and 1999. So it covered a decade in the former Yugoslavia, this international tribunal that we call the ICTY. There was no direct victim participation at the ICTY, the way we, for example, have it at the International Criminal Court. So victims, of course, sometimes participated as witnesses, but they were not really a party to the proceedings. The ICTY and the former Yugoslavia had really no cases that concern the crime of aggression, but I am happy to discuss the crime of aggression and efforts to establish a potential special tribunal for Ukraine in the Q&A if you are interested. So just to give you a couple of points on the Yugoslavia tribunal. So It had 161 defendants. It convicted 79 people, if I'm not mistaken, and it was operational pretty much for 25 years. So, 79 people were convicted in 25 years. And acquittals also happened. So people were acquitted in the proceedings as well. Some died before their trials were over. But with 161 defendants and people who were indicted, this tribunal is definitely, in terms of international tribunals and here in The Hague as well, the court with most experience, we could say, the court that has done the most work in terms of trials and cases. So some important fugitives, for example, Ratko Mladic and Radovan Karadžić, they were fugitives for over a decade, both of them. So this is the Bosnian Serb political and military leaders. They were fugitives from the ICTY for over a decade. However, the political circumstances changed in the late 2000s, and then they were arrested, tried, and now they're both serving sentences for genocide and other crimes. So this is just to say that other courts as well struggled, and the ICTY struggled with indictments against people who were not available, much in the same way that, for example, we can observe at the ICC now as well. I think an important note also to keep in mind is that there were no reparations options possible at the Yugoslavia Tribunal. So that is also a difference between then and some of the conversations that we are having now in relation to Ukraine. There were some successes many years later in local trials, for example, in cases of sexual and gender-based violence. However, again, reparations were simply not a big part of these proceedings. If you're interested in reparations, for example, in Bosnia and Herzegovina, you can look at the work of the non-governmental organization Trial, who is really active and has issued reports where information is available about how reparations worked and what the challenges were in Bosnia and Herzegovina domestically. So let me now say a few words about how domestic institutions in Bosnia and Herzegovina specifically, because I think that is the case that is most interesting and most relevant for Ukraine. What sort of is the system in Bosnia and Herzegovina, and BIH, as I will call it. So there is a court of BIH, so the court of Bosnia and Herzegovina, which also has a prosecutor's office in Sarajevo, which is where I used to work. And then there's also courts and prosecutors' offices at the more local level, at the cantonal and district level. So the prosecutions and investigations for war crimes were spread across the country, I think much like the situation in Ukraine is currently. So there was a division of labor between these different offices. However, it was complicated and it caused a lot of problems trying to figure out which court is best or which institution is best suited to prosecute a certain case. So also something to, I think about how to most efficiently organize the distribution of investigations and cases in such a way that efforts are not duplicated between different institutions. So theoretically speaking, the court in The Hague, the ICTY, was supposed to deal with the highest level of accused. So imagine country president, party presidents, commanders, so high-level accused. The court of BIH, the court of Bosnia and Herzegovina, again, more theoretically than practically sometimes, was sort of designed to capture mid-level accused, sort of mayors, maybe high-level local officials. And then the local courts were supposed to deal, for example, with individual soldiers, so people who were not particularly important, so to say. But again, this kind of idea about how division of labor should work did not always translate into practice, especially in the early days. The ICTY, the Yugoslavia Tribunal, was dealing with many cases of people who were really not high-ranking or particularly important at all. So I think this model of different courts for different levels of accused is a good one. And I think it's a good idea to create specialized courts and staff at the prosecutor's office to gather expertise and focus training and resources so that it's not spread out too thinly kind of across many different institutions. So I would say many challenges in Bosnia and Herzegovina specifically were similar to what Ukraine is facing now. So one challenge is, or was at the time in Bosnia as well, a lack of expertise in an area of law, especially because 30 years ago, kind of international criminal law was much less developed than it is now. So knowledge and experience in investigating these kinds of crimes was insufficient because there's really techniques and sort of things to know when we are investigating large-scale murder, large-scale detention, large-scale sexual and gender-based violence in cases that kind of include larger territories, months and months of, for example, occupation, several different detention, places of detention or prisons or camps. So it's really complicated. There's a need for in-depth knowledge and experience when it comes to these kinds of crimes. And 30 years ago, and I think in many places in Ukraine still, there is a struggle to conduct some of these tasks, especially at scale. So what I mean here is that a country may have 20 experts in ballistics, forensic science, DNA analysis, open source analysis, but 20 is not enough. You maybe need 300 to go through the investigations that you have on your desk. So this expertise and knowledge was really a challenge then, and I think it's a challenge now as well. A big difficulty, I think, was also in coming up with strategies and then following through and implementing them. Bosnia had a war crime strategy, kind of how to go about dealing with this load of cases that was left after the war, much like in Ukraine now. But it has never really been implemented properly. There was a lack of political will and resources to translate kind of idealistic goals into action. So when you have thousands of cases, which we had in Bosnia and Herzegovina, and Ukraine now has, I think, over 126,000 cases registered, so many times more than what we had in Bosnia, the crucial thing to understand is that one needs to determine what you will pursue as an investigator, as a prosecutor's office, because you can't pursue most cases. 126,000 investigations cannot be conducted at the same time, not even close. So we need standards and we need criteria to decide how we move forward. And we had the same issue in Bosnia as well. So some of the factors that we were considering were, for example, gravity. How grave was the crime, which might have to do with the number of people who were killed or harmed. But it's not only about numbers. It was also about what impact has a certain event, a certain alleged crime had on the community. What is the likelihood of arrest and then a subsequent conviction? We had to make sure that, or we wanted to make sure that the crimes that we were investigating and prosecuting that they were representative of overall victimization. So, for example, if the war sort of brought to us different kinds of crimes. So, for example, arbitrary arrests and detention in camps, beatings and murder. It also, we had cases of sexual violence, we had murder, we had torture, we had looting. So the idea was that we needed to prosecute cases in such a way that all of these different kinds of crimes were represented. So, for example, in the siege of Sarajevo, people were killed with shells, with snipers. So we also wanted to bring cases that represented that kind of a violation. So we were thinking about these different elements, these different standards to guide us, to tell us how to proceed and how to choose the cases that we want to focus on. One factor was also trying to focus on previously neglected crimes and those which were underreported. So, for example, allegations of crimes of sort of sexual and gender-based crimes against men were something that was, I think, generally underreported. So that was also made a priority, that to the extent that we could, we also kind of highlighted that crime was also taking place. I just want to say a few words about the defense of accused persons. SDICTY and locally was well funded overall, and I would say that was a must for the proceedings to be understood, to be and to truly be impartial and fair, because these processes only stand up to scrutiny if every single individual, no matter how important or not, how vilified or not, is well represented in court. So just a couple of more words before I move on to challenges and then accomplishments. So the ICTY, the Yugoslavia Tribunal, closed in 2017. There was a trial that was finished at the residual mechanism. I don't want to burden you with the details, but this is an institution that is that inherited basically the work of the tribunal. So all of it was finished in 2021. So the trials in The Hague are finished now for several years. The local trials continue. So now it's 30 years after the war. The local trials continue in the different republics of the former Yugoslavia, but they move on slowly. And generally speaking, there is a lot of critiques lately that these processes are flawed. And sort of, I think there is an understanding that the best days of war crimes prosecution in the former Yugoslavia are behind us for different reasons. And again, we can discuss this in the Q&A. But I just want to sort of draw a line and tell you that, so after 25 years of investigations and prosecutions in The Hague and across the former Yugoslavia, but these are trials in person. So I'm counting only in-person cases here. About 1,000 people were prosecuted. So in The Hague, in the former Yugoslavia, about 1,000 persons were prosecuted in person for alleged crimes in the former Yugoslavia. So, even if my numbers are a little bit off, maybe it's 50 or 100 more. But in any case, this is just to calibrate and to have a realistic idea about what expectations or how expectations for Ukraine, I think, should be guided. Attention is now elsewhere, away from the former Yugoslavia, of course, and that is understandable after 20, 30 years. Donors, supporters, society, or societies, I should say, move on, or they think they moved on. Survivors die, witnesses, So it's really important to kind of have this idea that even though there are no statute of limitations, so you can prosecute people as long as they are alive for these kinds of crimes, and we of course see that in relation to crimes of Nazi Germany still sometimes, rarely, but we see 90-year-old people in court for crimes from the Second World War. Realistically, in Ukraine, as in the former Yugoslavia, most is actually done in the fairly near future after the events kind of have taken place, the alleged crimes. So, in Ukraine, I would say there's 2 decades of real possibilities. And then I think it's going to become much more difficult. For example, donors move on, and some move on much earlier than 20 years. Let me just say a few words on challenges and accomplishments, what I see in the former Yugoslavia, but also I think elsewhere when it comes to what war crimes trials can do and what they accomplish. So one challenge is caseload. It was the case both in Bosnia and in Ukraine. The number of things to be investigated is overwhelming. And one so needs to decide on a strategy. And my sense is that in Ukraine, that strategy has not been figured out fully yet. That strategy, importantly, also must be explained to the public, and it must be made clear to survivors, but also the broader public, about what is possible, what can a judicial system do. And I think statements such as everyone will be punished, all war criminals will be punished, are not actually helpful, because they are not true, because they cannot be true. Even with the best efforts, most investigations, I don't think, will ever be conducted if we are to conduct them properly, simply because 10,000, 20,000, 50,000 cases overwhelms any system. Political will is a key factor. I have mentioned it before. It is often lacking. But of course, in Ukraine, it's not an issue of political will. The Ukraine, of course, wants to prosecute. What I think here is a place to be careful is that resources, money, trained staff are organized in such a way to maximize effect, because trials are long and expensive if you want to do them properly. But Ukraine is getting a lot of help from donors abroad and allies, the United Kingdom, the United States, the Netherlands, many different states, Poland, are assisting the Baltic states in all kinds of different ways. But the challenge is still, I would say, overwhelming. There is, of course, a challenge of accessing evidence, access to occupied territories, for example. And again, the volume of this potential evidence is enormous and hard to collect and sort through, and even have a good idea about, for example, what all the different non-governmental organizations are doing in relation to collecting potential evidence. There is also, and this of course was not the case so much in the former Yugoslavia, but is very much now in Ukraine, is a challenge of safety and security of online data, potential evidence and communication between different actors, for example, the International Criminal Court in The Hague and various domestic authorities, between different prosecutors' offices. There is a vulnerability, and of course we know that the International Criminal Court had a hacking incident a while ago, so it is a real threat. One more challenge is the fact that time passes, people's memory fades, suspects and witnesses die. So all of this influences the collection of evidence and presenting that evidence in court. Trials also, of course, depend on a broader social context. So, of course, what happens in the war in Ukraine will have a massive impact on what happens to trials. What I want to say here is that they don't happen in some kind of vacuum. And I think another challenge is that sometimes I think people approach war crimes prosecutions with the idea that they can do much more than they actually can. By themselves, trials, even when they're well conducted, even in the best case scenario, do not by themselves bring social repair, or prosperity in the aftermath of mass violence. They do not heal trauma or grief in and of themselves. They can be a part of the process that helps, but they cannot by themselves do that much in those broader sort of social terms. They do, however, accomplish many valuable things. And I think the first thing is they do render some justice to some victims some of the time. And this is the best case scenario. Some processes are fairly conducted. They're conducted on time. There is a fair outcome. People who are guilty are punished, and survivors feel some sense of comfort, I suppose, there. They, in the broader sense, they develop substantive and procedural law, they develop jurisprudence, and all of this can be very useful for others in other contexts. So what people did in the former Yugoslavia and then in Rwanda was useful to advocates and investigators and people collecting materials in Syria and sort of in Ukraine. So there's a sense of building knowledge and expertise and understanding about how to go about dealing with these massive, large-scale instances of violence and of course alleged crimes. One thing that I saw in the former Yugoslavia that had real concrete, positive and meaningful outcomes is the search and finding of mass graves, the finding of missing persons, and then the return of remains to the families that were looking for them. That was really meaningful in a very concrete way. People found a lot of comfort in being able to bury their loved ones in a dignified way. And this was often, the process of finding mass graves was often part of criminal investigations. So that's actually one part of it which has a very concrete, visible, positive outcome. This collecting of massive amounts of documents, evidence, statements, reports, satellite images, all kinds of, now of course, digital material, in the case of Ukraine, I would say is important for posterity and for future generations, irrespective of the outcome of the trials. I, for example, wrote my first book on paramilitaries in the former Yugoslavia, based almost exclusively on trial records, on transcripts, on evidence from the Hague Tribunal. So I would really stress how important this material is, irrespective or without it even having anything to do with trials themselves. There's a broader significance to this material. The accomplishment, I would say, is also an acknowledgement of harm and a recognition of facts. The fact that things are officially told, and facts are written down and saved for the future. I think this also has a really sort of positive long-term effect, because it provides also a public forum for survivors to testify. Of course, only a very small fragment of survivors actually testify in court, but the ones that do sometimes do feel like they have contributed to something important by telling their story. And finally here, through this acknowledgement of harm and sort of establishing facts, what trials are doing is also what an American legal scholar, Diane Ordentlicher, called a while back, narrowing the space of denial, which means that it becomes undeniable that certain things have happened. For example, I can talk about Srebrenica, which many of you will know was an instance of mass murder in July 1995, which has been ruled as a genocide by two international tribunals, so the Yugoslavia Tribunal, but also the International Court of Justice, also here in The Hague. Which has been in the news a lot, of course, the last few months. And And so this narrowing of the space of denial means that even in nationalists, for example, in Serbia in the last years, they don't say nothing happened in Srebrenica. They dispute the number of people who were killed. They dispute the legal qualification of genocide. They call it strašan zločin, a terrible crime. But no one comes out to say nothing at all happened in Srebrenica. It's a little bit like the Holocaust, where that position is really marginal. And so I attribute that fact to the amount of evidence and conversation that has been had because of these trials in The Hague, where it becomes simply impossible to claim that absolutely nothing happened there. We can discuss in the Q&A, if you are interested, the challenges that we see now, of course, with social media, artificial intelligence, how denial potentially can become a new phenomenon, or at least something that we haven't sort of seen before in the same way. And of course, the final bit on kind of accomplishments is that we are, when we have fair trials that result in a conviction, we are sending a message as a society, as the world community, about what we do not tolerate. Although, of course, critics would say that statistically, if you are a war criminal, and as I was saying just 15 minutes ago, if you are a war criminal, the chances are, so statistically, you are not very likely to face justice, especially not at the international level. So most war criminals actually historically, sadly and frustratingly, walk free. But at least in some cases, that message is sent, that we as a society try, in most cases, not to tolerate these kinds of crimes. And just to end on a few notes that relate to Ukraine and a few points on the ICC. So one problem or difficulty that I see in Ukraine, and I've been doing some research on that the last several years, is what many have called over-documentation. So potentially too many actors doing too much recording, documenting, without a clear coordination between who is doing what. And I think in the early days, maybe more so than now, issue of professional standards, issue of legal standards, that the material that is actually documented will be useful in court and will be admissible in court. So that, I think, is still a challenge, that there is an incredible amount of activity in Ukraine. Many people are doing different things. And of course, in many ways, that is good because things are being documented. There's a lot of interest in Ukraine. But at the same time, it can also have this really negative consequence that potentially so much is being collected by so many different actors that at the end of the day, in a decade, if a prosecutor somewhere needs some material, that there is so much and it's not necessarily searchable, that it becomes almost unusable. And I think that's a real danger. Another issue that potentially I think can also be important for Ukraine is that there is no lack of political will. We said that a few minutes ago as well. However, in the coming years, a thing to pay attention to is, will there be political will to also investigate when needed? So when we have initial prima facie kind of indications, will there be political will to also investigate, quote unquote, your own? So Ukrainian soldiers, for example. We will see what the future brings because states struggle with this. I can talk about Croatia, that's the country that I am from. And Croatia, I think, had similar challenges in investigating and sort of prosecuting its own sort of soldiers and members. So we can talk about that if you're interested. But it's very active, of course, in Ukraine. Domestically, I think over 50 trials have already taken place. I think some of them in absentia. there's something like 270 or something active investigations into cases of sexual and gender-based violence. So there's a lot of also interest in this topic, of course. But again, we have a question of sort of knowledge and expertise and access when it comes to this scale. The amount of work is simply great. One challenge or one question that I have as a researcher is, I don't know, and I think we don't have a lot of clarity as to what constitutes a case. When the Ukrainian authorities say we have 126,000 cases, what do they mean when they say case? Is this just a one-page criminal report about something happening? You know, a shell fell, 7 citizens were killed. Or is that something else? Because I think this kind of clarity would help also with public understanding about what is going on. And of course, there's, as I said, a lot of help and assistance and cooperation. And so I think the capacity is being built up, but I'm just not sure, you know, when this capacity would ever reach a level where it would be possible to do thousands and thousands and thousands of cases, because of course we also need physical infrastructure, technology, and all these kinds of things. So just to end on a couple of notes on the ICC and Ukraine. So of course the Russian Federation and Ukraine are not states parties, but Ukraine has recognized, sort of accepted jurisdiction twice, and many states sort of referred the situation to the ICC. So there's of course a lot of interest. We have 4 individuals with arrest warrants that we know about. So there might be others coming, or there might be others that we will find out about later. So of course Putin, then Maria Lvova-Belova, and then the more recent cases of high-level officials in the Russian long-range aviation, I think, and the other is the Russian Navy. So 2 individuals as well. There are, I think, not a lot of prospects for arrest at this moment. And again, this will depend on what happens in the future within Russia and elsewhere, if these individuals will potentially be arrested and then tried. But again, you know, international justice moves slowly. The fact that it's not possible today doesn't mean it's not possible some other day, because we had, again, similar situations in the former Yugoslavia, and people appeared at the court 10 years and more after being indicted. So as long as the individuals are alive, I would say there is hope that something like that would happen. And just to sort of finish off with a couple of lessons learned or things to think about. Again, just to hammer on this point, to emphasize, 126,000 cases means that sadly 90% of this will never be done in a traditional courtroom, because the judicial system has been designed to deal with crime as an exception. So 5 murders a day in a peaceful, generally peaceful society, for example, and not crime as a rule. So it's not designed for, you know, a breakdown of the rule of law, 100 murders a day, 5 shellings, you know, 13 rapes, 50 abductions. It's simply, it crumbles under this pressure. So I would say that goals need to be for domestic institutions in Ukraine, but also for the public watching the ICC, for example, that goals should be defined in a humble way and narrowly. And we have to be careful not to build up expectations in the public, because then the survivors, for example, just end up disappointed. And I don't think that's doing them a favor. It's very difficult to prosecute and investigate your own soldiers, but it's an absolute necessity if we want this system to be credible. So if there is a reason to think that Ukrainian soldiers in a situation in a specific attack or something should be investigated, then they absolutely have to be independently and impartially, the same way that anyone else would be investigated, because a system is credible only if it's impartial in such a way. We can also discuss in absentia trials. The general, I think, opinion by most experts that I am in contact with, and I think it's a fairly known position, that in absentia trials are generally not considered a great solution. And we can talk about why that is the case, but it's mostly a critique that has to do with the fairness of the proceedings. Croatia did these trials as well, and I'm happy to talk about how no one really cared about them in Croatia. No one knows about these trials happening, and it was just, I think, a very big waste of time and effort and resources. Communication is vital. So outreach, speaking to Ukrainians, but also many others around the world, stakeholders, about these proceedings regularly and in ways that they understand, because the law and legal institutions can be quite dry and difficult to understand. So it's very important that communication strategies are designed so that people can understand what is going on. And just one or two more points before I finish. As a researcher, as a historian, just to emphasize once again how vital I think it is that any transcripts, judgments, indictments, but also crucially evidence, to the extent that that is possible, is made accessible to the public and researchers in Ukrainian, in Russian, and in English online, if possible, again, because I think it's important to make it possible for people to do research based on these trials. It's important to have good journalists covering these proceedings so that we can read in the news what is going on in these various trials around Ukraine, but also elsewhere. We might see cases in other countries as well. And then, of course, just to finish, a massive task is in front of Ukraine. It will take decades, and it will be really hard. It will be disappointing. It will be frustrating. I watched 20 years of this in the former Yugoslavia, and it's really a roller coaster. You know, a success, a failure, a conviction that was highly expected. Someone dies before the end of the trial. So it's a whirlwind, so to say, of a process. And it's really difficult and sort of frustrating. But I'm sure many already are realizing that in the last couple of years following Ukraine as well. I would say that there can be no justice for what has happened and what was done. So that realization can help understand and accept what is possible within the judicial realm, which is, again, humble, but important. Ukraine has support, however, more support than probably any other country when it comes to domestic investigations and prosecutions. So I hope that it can really do its best in these circumstances and provide some justice to some survivors and bring some comfort to what is a hurt nation, which is completely understandable, and that it can help establish facts, save these archives for research, and conduct these processes while respecting the rights of the accused. That is really crucial, because I think in this darkness, witnessing, reading about, experiencing all these crimes and all this horrible, horrible violence, that we, members of the judiciary, researchers, observers, we must be careful not to become unfair ourselves. So I hope that was sort of within time. I thank you for your attention, and I'm open to questions and comments. Thank you.
Thank you very much, Eva, for your presentation. Of particular importance were the threats concerning the criminal accountability for international crimes at the ICC and within the domestic judiciary. And now I would like to invite Dr. Anna Adamska-Galant to give her speech. Dear Anna, the floor is yours.
Thank you very much, Andrei. Thank you very much, Eva. I must say that it's kind of challenge to make several comments after your speech, Eva, because you have made so many points that I also wanted to raise. So I will just strengthen and underline some issues which I find particularly important. So when it comes to the legacy of ICTY, I think it's very important that it was the first international tribunal since the Nuremberg trials, which finally put on stand, which finally which finally resulted in holding accountable people for gross violation of international humanitarian law. And actually, these ICTY and also Tribunal for Rwanda, it was like the new beginning for increasing or for bringing justice for these kind of atrocities. So this end of impunity, even if it's kind of symbolic, and even the fact that it's obvious that not every perpetrator will be held liable, it still shows that the end of the impunity comes. One point. Another point, Eva has mentioned the jurisprudence that has been developed, so many concepts that have been developed by especially ICTY and ICTR. And actually ICTY, especially at the very beginning of its operation, had quite a lot of time to develop concepts because there were not so many cases being brought with this court. And from my perspective, as a judge who used to work in the former Yugoslavia and Kosovo and this hybrid courts, this jurisprudence of ICTY was extremely important. So it was like that we were using on daily basis when there was a need to decide on various aspects of accountability for war crimes or for crimes committed during the armed conflict in Kosovo. So we were just referring to the jurisprudence of the ICTY, and I believe, and I also know that judges in Ukraine are using very intensively. What is very important that was also underlined by Eva. First of all, justice needs time, especially justice for such gross violation of humanitarian law. And this is obvious, and we have to accept that not every perpetrator will be held liable. So this question of expectation that the people, they must be aware that not every crime will be punished is very important. So this shall be properly communicated to the Ukrainian society, because of course this lack of accountability for perpetrators of many crimes can contribute further to traumatization of the victims, of these people who suffered. It's also blatant to everybody that actually the war in Ukraine is the best documented war ever, because actually now everybody has like the smartphone, can make a video, and the Ukrainian prosecution, Ukrainian investigators are overloaded with the amount of the evidence. And what is very important, this evidence needs to be verified, to be used in the properly in the court proceedings. Therefore, also this issue mentioned by Eva, the issue of prioritization, to make a strategy to decide which kind of cases are worth to be investigated, or we can afford to investigate, and we can afford to bring to the court. Also, in the context of dealing with war crimes, and this is a lesson learned, I think, from former Yugoslavia, not only from Bosnia, but also Croatia, Serbia, Kosovo to a certain extent, is a need of specialization. So it's not good if any court in Ukraine can deal with a war crime case, because this is the question of lack of proper expertise. And this lack of proper expertise, it refers to judges, it refers to prosecutors, it refers to investigators, and it refers to defense counsels. And this is very important, because this obligation to ensure, to guarantee a fair trial, this is the obligation of Ukraine as a state, to guarantee that every person that is putting on trial, charged with serious war crimes, has right to defense. So therefore, this need of specialization for judges, prosecutors, investigators, but it is also important from the point of view of ensuring support for victims, for survivors, for vulnerable witnesses who testify, who testify. We all know that the evidence that is being brought, that is being produced by these witnesses who are present, who suffered often most because of the crimes committed, is of the biggest value, or of a very big value. But this is also giving for them, giving testimony for them. It's a huge psychological challenge that causes trauma and may lead to re-traumatization. And therefore, there is this need that is already identified in Ukraine to create a network of support for such victims, for survivors, to help them to go through the criminal proceedings. And it's definitely much easier if such centers are kind of centralized, because it's not possible to have such a center of support in every single court of Ukraine, especially that we know that there are more than 600 of courts all over Ukraine. I have also made a note about the trial in absentia. I fully agree with Eva. The trial in absentia, it does not have a value like of a proper trial. And also in case of trial in absentia, this is always a need to repeat this trial afterwards when the defendant appears before the court, because this person needs to be guaranteed this right to a fair trial and right to defend themselves. I also want to underline, and this is, I think, very, very important, that when we look at this, what is happening in Ukraine, actually, Ukraine is in a very specific situation, because justice is being delivered, or there is an attempt to deliver justice during the ongoing conflict, during the ongoing war. And in the same time, when we look at judges, also judges, Ukrainian judges, they are also victims of this situation. Many of them have been expelled from their houses. Many of them have lost their loved ones. Many of them have suffered because of loss of property, etc. So in this sense, they all are victims of this situation that is happening in Ukraine. And you know, from a perspective of a former judge, I even cannot imagine how difficult it must be for them to stay impartial, to stay not biased, not to be biased in a situation when before the court is the Russian defendant is being brought. And this is their obligation as judges, to guarantee that the trial is fair. It is their obligation to treat the defendant impartially. And you know, when you think about this emotional state of judges, and judges are human beings, what is very often forgotten, it's really the burden on them is really huge, especially that there is also this pressure from the media. There is this expectation from the public, from the civil society, that every defendant who is put on trial, who is a Russian, is guilty of the war crime. And international humanitarian law is very nuanced. So not every death that is caused during the war is a war crime. And you know, for judges, this is their role to decide to properly assess the evidence, and if the person is not guilty, to acquit such a person. So and actually this like a response to such challenges, like lack of expertise, this risk of lack of impartiality, these are these solutions that sometimes have been applied, like hybrid courts, which are based on a presumption that there is like a participation of international judges who are embedded in national system, and they together with local judges decide on such cases. And I was working in such a system in Kosovo, where the idea was that international judges were sitting together with mainly Albanian judges who were delivering justice in Kosovo to decide on cases where which were connected with the armed conflict which took place in 98-99. It was the armed conflict between Kosovo Albanians and Serbs. And the idea was, or justification for involvement of judges from outside, judges, prosecutors, defense counsel from outside, was this need to ensure that every defendant standing before the court has a guarantee of a fair trial, has the right to defense, and will be adjudicated in a fair way. There are, so this kind of a hybrid solution may be considered, but what is extremely important, and I'm also telling it from the perspective or this experience that I received in Kosovo, is that international judges who are embedded in the system, first of all, they need to have proper guarantees of their independence. In Kosovo, it was, I would say that it was like a mistake that was made by the international community, that judges, these international judges, were somehow embedded in the political body or administrative body. In a sense, it was an advisory mission of European Union, which does not ensure, does not guarantee, does not guarantee full independence of judges. So a lot depended objectively on like a moral spine or integrity of a personal judge, how he or she would deal with these kind of challenges and pressure, because it had happened, like a political pressure or any kind of pressure that you can imagine. And this is also the issue that, there is this always the ongoing discussion, what is more important, stability or justice? And when we are talking about transitional period, like in Kosovo, where the rule of law was being implemented by the same, or in cooperation with the same people who later were accused of committing war crimes. And this resulted in Kosovo, this combination of facts, I would say, this lack of proper guarantees for international judges, combined with weakness of local judiciary that was exposed to a lot of pressure, and also combined with a very specific a society in Kosovo, which is like a clan society, which is a very small society, because Kosovo is like around 2 million people who are living on the area. I believe it's like Zakarpatska Oblast, so like the smaller part of Ukraine. So these all people are somehow connected with each other. Therefore, the biggest challenge that we faced when we were dealing with war crime cases, and majority of them were against Albanians, who were treated by Albanian society as war heroes, not war criminals. So it was like a pressure on witnesses, pressure and threats on witnesses. And this was the challenge that international community and local judiciary was not able to handle. And it resulted in this, that I believe it was 2016, that international community decided to create another hybrid court for Kosovo. But this hybrid court now is called the Specialist Chamber, the Specialist Kosovo Chamber and Prosecution Office. It is located in The Hague. It is filled only with international judges and prosecutors, and only international staff works there. They still apply Kosovo legislation, but they are not located in Kosovo. And thanks to it, the prosecution office of this Kosovo Specialist Chamber managed to file indictment against top-level politicians of Kosovo, like the former president Hashim Taci, who is being charged with serious violation of humanitarian law now. Of course, when I talk with my colleagues I will be always feeling myself a judge, to be honest, regardless, I'm no longer a judge. But when I talk with colleagues from Ukraine, and they often admit that this kind of, how to say, international support on the bench would be appreciated, because on one side, it would bring expertise. On the other side, it would help to take the burden from local judges, from national judges, on deciding on these very difficult cases. But of course, this is the debate or the discussion that can take place only after the war in Ukraine is finished, because this would require the amendment to the Ukrainian constitution, which cannot be changed during the wartime. So just to sum up, from my perspective, very important, this is the specialization of judges, prosecutors and investigators, and also of defense counsels, because the fair trial require participation of experienced defense counsel. Another important element is adoption of the war crime strategy, because absolutely, it's not possible to proceed, to prosecute, to adjudicate all cases, especially that we are talking about like 100,000 of cases. But I agree with Eva that this is the question how it is also being counted. Also, I think that it's very important, and I know that Ukraine is doing this, is establishing effective cooperation, international cooperation with partners all over the world. And we know that, for example, the prosecution office in Poland, in Lithuania, in Latvia, and other countries, they have been involved already in investigation. There is also cooperation with the International Criminal Court. There is a need for this continuous support from the international community to build the capacity of Ukrainian actors, judges, prosecutors, and investigators. And last but not least, this campaign, this outreach campaign, on one side, concentrated of reducing expectations. This is something that needs to be done, but also the campaign that would allow to disseminate this, what has been already done. So as Eva said, like publication of judgments, reasonings to judgments, the evidence that was used to establish the facts, of course, in the scope that is allowed under the law, not to undermine the ongoing proceedings. And this is absolutely true that one of the very important element of the legacy of the ICTY is this enormous fact-finding. So if you take any judgment of the ICTY, like a significant part of the judgment, this is the context, this is the history, this is the description of various elements which build this whole picture of the armed conflict that took place. So I would say that this is all from my side, just to contribute to this what Eva said. Thank you very much.
Thank you very much, Anna. And now we move on to the questions, but I actually didn't see questions. Do you see maybe someone?
This moment, I don't see any questions. I also do not see any questions in the chat. So if there are any, they can be put also here, like in the chat, or the question answered. There is one hand raised. I see. Just a moment. Caroline Edgerton. I'm not sure if, yes. If you could write the question or your comment on the chat, because I'm not able to promote you to the panelists.
Okay.
Here is the question.
It is. I will read this question. It's a question from Olga Lunova. Agreeing with Anna's statement, that the war crimes specialization for judges need to be established, such that only Ukrainian judges, specially trained in humanitarian law, should adjudicate war crimes trials. We hope that this practice will be established in the near future.
Mhm. If I may add like a short comment, this is what is happening in Ukraine. A lot of trainings is being delivered to Ukrainian judges by various partners, because as Eva said, there are a lot of international organizations, projects, etc., who are working in Ukraine, who are supporting Ukrainian judiciary. And also from my perspective, because under EU Prawo Justice, we have been also conducting various trainings for judges on the international humanitarian law. What is visible, there is definitely a progress, because at the beginning when we started with trainings, everything was obvious for Ukrainian judges. So there was no question. There was no question to simplify. The Russian killed Ukrainian, this is a war crime. And now we see that there are more and more questions, more and more problems that are being seen by Ukrainian judges and prosecutors, because they have already learned that international humanitarian law is very nuanced. So it cannot be such a simple black and white approach. And when they put more and more questions, also based on their experience already from these cases which they have heard, it shows that there is development.
Second question is from Norman Mayer. Is there a judicial structure already being established in Ukraine for war crimes cases, such as a central court for a higher level cases and defendant and so on?
No, there is not such a court established. So in theory, each court in Ukraine can deal with a war crime case. There are some discussions, but no decision whether such a court, or at least courts, should be formed in Ukraine.
If I can say, just from my experience in Bosnia and Herzegovina in relation to this, as Anna was just saying, I've already also heard about discussions and debates about how this should be organized, because I think different actors, Ukrainian and from abroad, realize that some organizational issues, distribution of work, and such things have to be resolved to maximize efficiency. But indeed, it hasn't been yet decided that there should be such a centralized, for example, structure like we had in Bosnia, where, for example, in Kiev, you have a kind of a court that deals with potentially higher level accused, and then in the kind of local, kind of in the oblast sort of regions, in the regions that there may, for example, be courts that deal with kind of smaller cases. What I think is a good note of warning, so to say, is that there are often in such situations tensions, maybe some competition for attention, for resources between the central, so to say, the central office, for example, in Sarajevo, or maybe one day in Kiev, and in the regions. There is a sense of sometimes jealousy about who gets this case, or maybe sometimes one office wants to dump a difficult case to someone else. So this also needs to be taken into account, that sometimes these kinds of divisions also bring significant tensions within the same judicial system between colleagues. Sometimes it can be a little bit tricky to figure out how to do.
Thank you, Eva. And next question is from Dima Gadomski. 2 years ago, Russia attempted to create a tribunal for Azov, which looked very much like a trolling of the core idea behind the tribunal. I'm afraid that we will have see the same story in the future. Russia will be further trolling any international tribunals created for Ukraine by creating the mirroring international tribunals in Iran or Belarus. Final question: any ideas how to overcome this trolling?
I think this use of the word trolling is really interesting and I think quite innovative. I would say this to Dima, to a certain extent. Various states around the world try to manipulate, present proceedings in ways that are politically useful to them. So Russia is nothing special in this regard. States try to manipulate all kinds of institutions internationally, do things that look good for them and look bad for their adversary. So I'm not sure if we can really prevent this. One thing that I think is a sort of a prevention is the understanding that certain institutions have more international legitimacy and certain institutions have less. So I would say any court that is made against a particular actor, so court against Azov, to me, as a professional, as an expert, immediately sounds wrong, because the idea is not to establish a court against an actor. The idea is to follow evidence, follow facts, and then bring cases wherever they may lead you. So it could be a member of this group or this unit or that group of that unit. So I would say that many people who would read about such a tribunal will understand that what we're talking about is not a legitimate institution that states and other actors across the world would sort of cooperate with. So I think we should always be mindful about this issue of legitimacy. And that brings me back to also the Ukrainian domestic judiciary in investigating properly their own when evidence shows that, you know, there's good reason for it, because we've heard examples from Kosovo, we've heard examples from Croatia as well. This is very difficult, but it's something that brings you legitimacy. If Ukraine is able to prosecute their own when they need to, then internationally they will be considered more legitimate, because look, they are capable. They can also impartially investigate their own, which means that they will probably also approach other investigations in such a way as well. So it's a good question, but I'm afraid, you know, here in The Hague, we see, you know, all kinds of spins about proceedings at different courts. So I'm afraid I'm not quite sure that we can do something to truly prevent it.
I remember that at the very beginning of the war, there was this kind of declaration of Russia to make like an international court composed of judges from Republika Luganska and Republika Donetska. And this is the question, as you said, of legitimacy and recognition. And also coming back to this ability of the state to deal with its own crimes committed by its own soldiers. It's extremely challenging, but this is unfortunately like the nature of the war, that war crimes are being committed on both sides. Of course, the scale, there is like the difference of the scale of number of crimes committed on one side, the other, but it happens on it may happen on both sides, I would put it this way.
If I may just add one thing that I see in the chat, because it's from Carolyn Edgerton, and she is a good friend of mine. So she's also a former prosecutor at the ICTY. She's a Canadian lawyer with a lot of experience. She's also worked with civil society in Ukraine. So her comment comes from a very informed and experienced place. And what she's basically saying is that she worked on Sarajevo-related cases. So it was about the siege of Sarajevo. It was about shelling. It was about sniping. 10,000 people were killed, over 1,000 children in this long campaign. So what she is pointing to is that, again, you can't prosecute all the individual cases, but she is bringing our attention to this idea that we show and demonstrate as prosecutors patterns of behavior, patterns of crime. So, okay, we can't prosecute every shelling, every detention, every arbitrary arrest, every sniping, every rape. But the idea with higher level cases, such as the ones that Carolyn was involved in at the ICTY, was about demonstrating and proving that it was a pattern of crimes, and that patterns also sort of demonstrate and show political planning, so that it's not, oh, the fog of war, oh, these crimes just happened, you know, no one ordered them. Because when you prove that they're that they're perpetrated in such a systematic, similar way across municipalities, across time, then it becomes obvious that there's a policy behind that, and that I think raises an issue to another level. So
Yeah,
thank
it's
you
like,
again, Carolyn, for this point.
yeah, it's like climbing the ladder. You start
Yeah.
from these low-level people, you gather evidence from them, and you try
Yes.
to reach these who are the ones who decided.
Exactly. Yeah.
Mhm.
And the next question is from Nikos Moraitis. Since Article 27 of the ICC Statute stipulates that official capacity is not a barrier for indictment of such grave crimes, then the only obstacle in enforcing the warrants already issued by the ICC is political will.
I mean, the only obstacle is the fact that the people who are under arrest warrant don't travel to places where they're going to be arrested because they're not stupid. So Putin, as long as he stays in the Russian Federation or its allies and friends, Belarus, Syria, North Korea, Iran, China, they would not be getting arrested. There was already some effects of this arrest warrant. I think last year there was a BRICS summit in South Africa. He was supposed to travel, and then he ended up sending Lavrov because he was afraid that South Africa, as a member state, would have an obligation to arrest him because all ICC member states do. So for these kinds of crimes, so war crimes, crimes against humanity, genocide, you can be a president, you can be a commander. It doesn't mean anything. It's just that people who are on these arrest warrants that are public will, I mean, even if they're not public, I think many people that are high-level officials, military or political in the Russian Federation are thinking twice these days before they travel because they don't know where they potentially could be arrested. So the only obstacle is the fact that they are not available to any state that could then sort of pursue an ICC arrest warrant.
The next question is from Anonymous, Anthony. I don't know if any of you have seen Slovenian film called Sarajevo Safari.
I know of it. I haven't seen it, but I know of it, yeah.
However, the author of the film has filmed the testimonies of witnesses, and there were also evidence that also rich Italian, German, etc. tourists have shot Bosniak in Sarajevo during the Siege of Sarajevo as part of tourist experience. The film came out 30 years after the siege. Why do such testimonies come out after so many years? Due to general trauma, due to amount of lack of resources and too many committed crimes, due to the fact that witnesses feel safe to talk only after decades after the event. The same will probably happen also in case of Ukraine. I would like to hear your view. Thank you so much for your answer.
So what I can say about that is I haven't seen the film, and I have lived in Sarajevo and worked at the prosecutor's office there for several years. And I don't know the details of this case. I know that there are accusations that have been made in numerous instances about this alleged kind of series of events where you had tourists potentially flying in and attacking civilians under siege. So there I have heard allegations, but I have never seen any concrete evidence, and I haven't seen this film, so I can't speak of the details. I will say that, and you know, this is just a more general comment, that many crimes, sadly, can be perpetrated without leaving a sufficient trail that is found. So for example, we had mass killings where there were 3 or 4 perpetrators. They killed members of a certain family. There were no witnesses that were surviving. There were no documents. None of the perpetrators decided to speak against their colleagues, against his colleagues, because it tends to be a he. And so a crime was committed. Civilians were, you know, shot, but there is no evidence. So there will be these situations, and this might be such a situation, where crimes have been committed, but there's simply not enough solid evidence to take it to court. Because again, just to remind sort of the audience, is that when we speak to one another in such a situation, over coffee, over a drink, our understanding of what is needed for us to declare something a fact is not the same level that judges use, for example, in an ICTY courtroom. The standard is beyond a reasonable doubt. That's a very, very high standard. So maybe investigators just figured out that we simply don't have enough here to make a plausible case. And here's 5,000 other potentially more plausible cases. So again, speculation, but just to draw our attention to the fact that evidence doesn't always exist, and that the standard that the judges tend to apply, and I'm sure Anna will also have something to say about this, is that it's simply not the same when we sort of understand what it means to say this person is guilty of this and this sort of crime.
Yeah, definitely you need the evidence, especially that this is such a lapse of time since the events that have been covered allegedly by this film. I haven't seen it neither. But on the other hand, if I think about the situation that this could have happened, this Sarajevo safari with rich foreigners coming to shoot. So if I can imagine me like a psychological situation of a witness in such a case, because you not only you deal with people who are extremely cruel, but also who are extremely rich to pay for such a trip. So I think that this is just a fair, potential witnesses of this horrible event. If it happened, they could simply feel threatened, and even after such a lapse of time, they can be really afraid that they can be reached by these alleged perpetrators. Especially that this is also my experience from Bosnia, Kosovo. I was working on the case that involved a lot of witnesses from Bosnia, so I'm aware of kind of threats and the way how you deal with witnesses that you do not like.
Yeah, and maybe just to add that also a lot of these crimes, there is no paper trail. So a serious prosecutor thinks 5 times before taking a case to court that is based only on human testimony, because people lie, people forget, people change their testimony for 1,000 different reasons. So I think prosecutors want to make sure that they can triangulate. They can bring a statement, they can bring an order, they can bring a survivor who can say something, maybe an insider witnesses who can corroborate, because that makes your case stronger. If it's a bunch of statements, so people saying that they have seen something 30 years ago, I just think that the prosecutors would be like, thanks, but that seems a little bit, shaky.
Yeah, in case where you have also victims of mass atrocities, there's also something like collective memory that is being developed through the generation.
Through telling and through discussing.
Through telling, especially in such societies. I think that I can say that in the Balkan that there is like people like talking, and like telling stories, and this contributes to building this collective memory, which can contaminate, let's say, the memory of an individual.
Yeah, absolutely.
And we have the last one question from Emilia Klebanowski. I'm just curious, do you know if there have been any court cases against Russia actors committing gross human rights violations in Ukraine, in Russia itself? Question.
I don't believe that, especially that Russians, they are using, the criminals whom they release from prison, criminals convicted for the most cruel criminal offenses. I don't know, but I don't believe that they.
From what I understand, Russia has a fine legal framework where one could do all investigations within a civilian or a military sort of judicial system. But I think the problem, again, much like Anna alluded to, is political, in the sense that the very idea about what kind of a war this is and who caused it and who is doing what is a reality that is much disputed. And of course, we have seen the regime in Russia becoming more and more oppressive. about the ability to even talk about, hey, maybe someone from Russia is doing some things that they shouldn't be doing. So I think the political sort of kind of hold that the situation the regime has over, I'm sure there's some lawyers, some judges, some prosecutors, some investigators, some journalists who would potentially look into these cases, but they simply don't feel safe in the political atmosphere in Russia now, where the opposition is either killed or in prison or fled. I simply don't think that it's realistic to expect that someone would bring these kinds of cases in Russia and survive to sort of see them playing out.
That was our the last one question. So if we don't, if anyone don't have a question, I think we come to the finish our webinar. I would like to thank our speakers. Thank you very much, and all for participation in our webinar. I encourage you to support the Sunflowers project. The operation of our application, which collect information on war crimes in Ukraine, requires constant support, in particular to ensure the operation of secure servers and IT support. You can make a donation through our website. I invite you to follow Sunflowers on our website and social media. We will keep you informed about our next webinars and other events. Thank you very much, Prawo Justice EU project, for organizing this event. Thank you all again, and see you soon. Thank you very much.
Thank you for having me. Good night, everyone.
Thank you very much. Take care. Stay safe. Good night. Bye.